we do handgun cases, we do weapons cases in this office, and we've done many over the past 30 years. In Maryland, if you purchase a firearm legitimately through a qualified gun dealer, you can carry that firearm to and from the gun dealer and to your home and that of the gun dealer who you purchased it from, or from your home to the range and back. You can't just be driving around with a gun in your vehicle unless you have a concealed carry permit. If you have a concealed carry permit, that's okay. If you don't have a concealed carry permit, that gun must be placed in the back of your vehicle in a container and separate from the ammunition. The reason is the law is designed to prevent road rage incidents, right? Where people get angry and they have quick access to the weapon, you pull the weapon, they fire at another motorist, and then you have mayhem on our roadways. If you are not authorized to have a concealed weapon, your weapon must be out of reach, must be a closed container at the back of your car, separated from the ammunition. We had a case recently, however. Young man was stopped, ostensibly because his vehicle, the windows were tinted beyond the legal limit. They never really explained what that was. But when we got the probable cause statement, what we noticed was, and that's the importance to potential clients and to other lawyers who will listen to this, is read the probable cause statement carefully. That statement is what the police officer involved in the arrest will write up. Normally they will type it up, stating what the particular offenses charged are and giving a narrative as to what led to the arrest. So it would typically start as follows and say, as follows: on 1st March 2023 at 10 a.m. in Prince George's County, I was executing a patrol at Bowie Center when a vehicle went by my marked cruiser. That vehicle had windows which I suspected to be in excess of the legally permissible tint. In this particular case, the officer said the vehicle went by her marked cruiser, but she didn't say it was going in excess of the speed limit. She didn't say that there was a tint which appeared to be in excess of the legally permissible level. And she radioed ahead to 2 other police officers, and they stopped my client. So when I interrogated her, I said, when the vehicle went by your cruiser, what crime, state to the judge what crime it was the defendant had committed. At that time, she was unable to cite any violation of law. And the violation of law could have been speeding in excess of the speed limit, the tint question, bobbing and weaving, improper left turn, improper right turn. You know, if you're at night operating with one headlight as opposed to 2, if it's at night again, not having your lamp at the back over your registration, any one of those things could have been sufficient probable cause to execute the stop. When she was unable to do that, and I then tackled the 2 other officers, I said, first of all, you stopped that vehicle because you got a call by radio. Yes. And at that time, did the officers say what it was that person had done that was illegal? No. So I had the first officer well sequestered within that zone of having violated my client's constitutional rights, and the second and third officers as well. And we moved to what is called suppress the fruit of the poison tree. What was a poison tree? The illegal stop. What was the fruit? The handgun. So my client did have a handgun where he should have had it. Of course, the handgun has been forfeited. We didn't bother to even go back for it, and he got off, and we warned him not to do it again. That the fact that we were able to succeed in this particular instance doesn't mean that he has to be a serial violator of law. We do want our streets to be safe. We don't want people hanging around with guns in your cars for obvious reasons. But if you need a lawyer who knows the law and who can handle issues of due process and lack of probable cause, come to us. I will be happy to assist you. Thank you.